Yes.
Yes.
Good. I put the name tag too, so I know.
Okay, that's good.
Did the police enjoy their lunch yesterday?
I don't know. I sent them trays and trays of
I
food.
saw. To, um, you know what?
You know we cannot ask. That's why I thought this is tighter. And people say, no, it's not, it's the same. But they say that we cannot, because we have a coffee yesterday, but if we cannot move to the center table, it should be the same. That's what they told me. But I said, well, small, I have a little bit more room. But it's frozen, right? I'm not a big crazy. You're welcome. Jacket, shorts. Like this. Yes.
I have a protein bar. Things get really tired tonight. I don't know. It's really good. I have this in my pocket.
It's nice, but it's not. It's nice. This should be this. I like these training session meetings. I learn a lot.
Hi, Mike.
Yes. Okay, we'll call the meeting to order. We'll start with the pledge.
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty, and justice for all.
Vivian, can we have a roll call, please?
Commissioner Blaylock. Commissioner Gratiter. Commissioner Levine. Commissioner Marshall. Commissioner Wamanani. Here. He's not coming, right?
Carrie's not coming tonight.
Okay. Commissioner Robach is absent today, and Chairperson Blaylock.
Here. All right, the next item is the approval of the minutes of October the 5th, 2023. I will entertain a motion to approve.
So moved.
Any discussion?
Yeah, I have one question on the second page. There's a third paragraph down.
Carl, is your microphone on?
Yes, it is.
Good.
The third paragraph down, it's talking about the brunch factory has a capacity of 265 in the shared parking lot with the shops of Riverwoods. Shouldn't that be Colonial Court?
Yes.
Okay.
Yeah, it was Colonial Court that had 125 spaces.
Where are we?
It's right here where it says the brunch factory has a capacity of 265.
Okay,
That should probably be a seating capacity.
Right.
with Colonial Court. Okay. Has a
And-
seating capacity.
And the shared parking lot with the shops has 125 parking spaces, which would make it clearer.
But actually, it's not the shops, it's
I'm
Colonial
sorry,
Court.
Colonial
Yeah.
Court.
Colonial
Yeah.
Court,
Colonial Court. Thank you,
Okay.
Carl. Way to miss that.
yes. Any other?
No, that's it. That's all I have.
Anybody else have any? Okay, let's approve or disapprove. So let's have a,
Be all in favor of the minutes as amended.
as amended. That's
A
correct.
voice vote's fine.
Voice vote's fine?
Yeah.
Okay. All in favor of the approval of the minutes as amended, please say aye.
Aye.
Any against? All right. Thank you very much.
But I abstain because I wasn't here,
Okay,
so I couldn't approve them.
Okay.
okay. Thank you very much. Do we have any visitors wishing to address the Plan Commission tonight? I do not see any. Moving on to new business, the training workshop presentation by Tesca.
So maybe I can give a real brief introduction to Michael Blue. He's with Tesca Associates. We asked Tesca to put together a small training session for new commissioners, as well as kind of a refresher to existing commissioners. And we think that we can get through this presentation in about an hour or so. There's really two parts of it. If we get to the second part, don't know. The first part really goes through procedural aspects, and then the second part gets into more of the code issues. So if we need to get to a breaking point, Michael knows where that's at. That'll be somewhere after we get through the obligations of the commission itself. So at this point, I'm going to turn it over to Michael.
Thank you all. How are you doing tonight? Now, I'll warn you, this is not a presentation, it's a discussion. So you're more than welcome to sit and listen to Lee and I talk at you for an hour. But if anything on a slide catches your eye or you want to discuss anything further, interrupt us, slow us down. This works better as a discussion. Lee and I do a lot of training for commissions. And so some of this is tried and true. Some of this is geared very much toward the village. But we thought we would spend an hour walking through. And for those of you that have been doing this for a while, this will be a good refresher. For those of you for whom this is your first meeting, it might be a little much. So again, we're not going to read the slides to you. You've got them in front of you. But if we skip over something or you have a question, slow us down. Does that sound like a deal? And we'll cover this stuff in about an hour and see how it goes. Good? All right, let's get going. So in terms of what we're going to cover, oh, look, we've already done number 1. See how quickly we're moving? In terms of dealing with development review and the things you have to do when you have an applicant in front of you and an audience and residents that are here before you, it's important to keep in mind there are different roles. There are different actors that are part of the process, and that's a good way to understand it. And so we'll start with that. The other thing we'll talk about is the running of a meeting, which can be a challenge, whether you're the chair or not. And then we want to talk a little bit about how subdivisions work and how planned unit developments work. But let's start working our way through 1, 2, and 3. And if we feel like continuing, that'd be great. If we want to take a break and finish another time, that's fine too. It's kind of what Steve and I were talking about. So roles in the process. We can go to the next slide as well. So the role of the commission is spelled out in the village code. It's not something that is random or something that the chair makes up or that Bruce cooked up one night. Although I guess you could have put it in the code, I suppose. But this is common. These things are always in the code. It's spelled out. It's very specific about what you as a commission are specifically empowered to do. So I think it's important just to note that this is not random. This is not just, oh yeah, we sit and listen to these meetings and hearings. There's quite the process for it. And so in terms of jurisdiction, 1 is to hear amendments and special uses and forward recommendations to the village board. That's kind of our first stopping point here, right? Is that you are a recommending body and the village board has the final say. The village board can accept your recommendation, they can amend it, they can decide otherwise, but you're a recommending body. You are specifically responsible for holding the public hearings. Real briefly, let's take note of the fact that there are public meetings. This is a public meeting, right? There's public here. Anytime the commission gets together, it is a public meeting. But there's a difference. When there is a public hearing, you're taking testimony of a very much more specific, detailed process. That's when you're doing these special uses and amendments and such. So you might hear the terms used interchangeably. They're not. A public hearing is a very specific thing. A public meeting is pretty much any time you get together. The other thing that you are empowered to do by the code is to initiate, direct, and review from time to time studies that relate to the code. So for instance, the discussion that you've been having with Lee and that I've been able to participate in about how should we maybe look at changing the PUD ordinance or adding to the PUD ordinance. That's specifically specified in the code. And then last but not least is the idea that whatever other powers you may have, this is sort of the legal catch-all because some of the powers of a plan commission, specifically that of doing the plan, are specified in the state code. That's the next slide. So to summarize, if you will, the role of the commission is to make recommendations to the board regarding these items here. The comprehensive plan, annexations of property, special uses, subdivisions, plan developments, and other duties as assigned by the village board. Other duties as assigned is sort of the official catch-all. Sometimes there will be an issue that will come up that the village board will want to consider. So in other communities, we've seen the village board decide, you know, we need to think about how we can more incorporate sustainability or electric vehicles or things like that into our codes or into our planning. Let's have the plan commission look at it. And then you would work with staff or maybe even have a hearing on it to let the public participate. But that's part of the process as well.
I'm going to jump in.
Please.
Enliven things a little, or not. One example of this, another thing to add to this list would be zoning text amendments. So in the past, the Plan Commission has examined the definition of family because we have single-family zoning, and then we say the zoning is for single-family homes, and then we have to, what is a single-family home? It's a home that's occupied by a what? Well, we tried to modernize that. We spent about 8-9 months at the Plan Commission looking at functional definitions of family, and then we made a recommendation to the board, and then they amended the zoning code. So that's an example. We had the same, I think as part of that discussion, we ended up doing something about group homes, which we now have as possibilities in certain districts. So that's another example.
The only thing I would add is that in the great majority of cases, those types of things are referrals from the village board. They're not initiated by the plan commission itself.
What about you as an individual commissioner, right? What are your responsibilities? And these are a little bit of, everything I needed to know about it, being a commissioner. I learned in 5th grade or whatever that book was. So some of this is sort of understandable, but some of it is worth talking about. One is to stay informed on local planning and development issues, which is often as easy as reading the paper or certainly the village newsletters and staying up on what's going on, talking to friends and neighbors and that sort of thing. Staying current on planning tools and techniques, which is not necessarily as easy, but I would suggest to you that there are any number of websites that can be resources. There is, as Lee and I know all too well, the American Planning Association is a national organization. Planning.org has got a lot of resources, an entire section of their website that's specified for plan commissioners. That's got all sorts of information on what to read. So there are tools out there that are readily available. And of course, the Google machine will find you anything that you want once you look it up. The other thing that we always talk to folks to do, talk to you about doing, is to visit the development after construction and occupancy. Usually what you get told in this kind of situation is go to visit the site before the meeting, right? And we certainly recommend that. Even if you drive by it every day on your way to work or the store, drive by the site and look at it with an eye towards what's coming, right? So that there's tremendous value in that. You'll see it differently. But I also tell people to drive past things when they're done, because you're looking at two-dimensional plans and graphics and pretty pictures and whatnot when you're deliberating and hearing from applicants and hearing from your neighbors. So it's good to see what it looks like after, so you kind of start to create those connections in your mind. The other is this collection of Be Prepared. Obviously, if there's a packet to read, it's great to look at it beforehand. I mentioned visiting the site. You should understand the comprehensive plan in the zoning ordinance. It doesn't say read the whole thing, so if you haven't, that's fine, but it's good to understand what's in these documents. And if you have any questions about any of that, call staff. I would suggest to you that perhaps the best advice we give in doing these sessions is call staff. If you have questions about how something fits in, how something relates to the plan, how the zoning works, to absolutely call Steve. And that is okay, isn't it? Okay, good. I never check before I suggest that. Also, especially if you have a question about the case that's going to be before you, right? A lot of times what happens is it happens during the meeting. And you say, when this happened 3 years ago, we did X, Y, and Z, and what's the, well, it's hard to answer that question during the meeting. If you call the day of or the day before, you get a chance, staff has a chance to do a little bit of research, look things up. I used to work with a plan commission chair in Highland Park, who you all know because he used to be the plan commission chair here, Scott Levenfeld. And Scott would call me as a community development director the day of the meeting, and he would say, Michael, here are the questions I'm going to ask you tonight. Part of it was because he wanted to know the answers to those questions. He was unsure what it was. But the other thing is he wanted to make sure that things were going to get on the record, that he would ask questions that he wanted to be sure the public could hear, folks at the meeting, folks that were watching. So this idea of being in touch with staff, if you have a question, is really very important. Next slide. Once you get to the meeting, the idea of being an active part of the process is also important. You don't have to do the thing where every commissioner says something like a lot of meetings go on. But if you have a question, ask. What's the phrase? There's no such thing as a dumb question. There are dumb questions, trust me, I've heard a lot of them, but none of them will come from you, I promise you, right? If you have a question, and the other thing that I find is that sometimes somebody will ask a question, they're a little hesitant to ask it, and it's something that seems kind of matter of fact, and you see all the other heads on the commission doing this. So if you don't know, absolutely ask. You are entitled to that information. You need that information to make a good decision. And then the rest of these things on here about listen attentively and consider the plan and that sort of thing. Those things are pretty standard. Part of what goes on, part of the deliberation between you all when the presentation is done is important, and we encourage you to take part in that. The other thing to be aware of in terms of responsibility is that, again, through the American Planning Association, there is a set of ethical principles in planning and Plan Commission ethical and planning ethical policies that you're not bound to. As certified planners, we have a code of ethics that we're bound to, very much like the legal profession does, or village managers also have. But the idea is mostly about, and if you went through and read these statements, you'd see it's mostly about our collective responsibility to serve the public good. Again, I don't think that's going to surprise anybody, but it's good to know that there is a structure and there is a format for it. And so if you, again, planning.org, if you want to go look for those things, that's really a good way to be connected to it. Okay, let's go to the next slide. As I often say, and this is not just because I used to deal with Scott on a weekly basis, the chair is really the most important person at the meeting, so congratulations. Because there is, as you all know, there is a decorum to a meeting. There is a flow to a meeting. There's a logical order to the meeting, and it's really the chair's job to manage that, manage the flow, manage the decorum, make sure that all the public is heard from, make sure the interested parties have input, all these sorts of things, keep things focused on what's going on, stick to the agenda, all that sort of stuff is important. The reason we put this up here is to also let you know that if you've never chaired a meeting, it's sometimes like keeping all those plates spinning. There's a lot going on. There's a lot of moving pieces. And it's certainly appropriate for the chair to look to the attorney or to staff and say, what's our next step here, right? So the other thing that I have seen, either vice chairs or other members of the commission, if a meeting was getting a little intense or whatnot, was to help out the chair and say, excuse me, Madam Chair, isn't this the time where we do X, Y, and Z? So I like to describe being a plan commissioner as a team sport, right? So this is something that we all do. The chair is absolutely the focal point of how this works. A lot of times if a meeting becomes a little bit heated and people are kind of pointing at each other or saying things to the developer, the chair will often say, let's direct all the comments to the chair, right, as a way to calm things down. And that's an important role, and it's up to all of us, frankly, to help you do that.
We're going to get to the role of the Plan Commission separately, but I think that last item, which is that you are a team member trying to support the chair, it is always helpful for, in addition to assuring that the public directs its questions to the chair, is that you as commission members as well do your best to direct your questions to the chair so that we have essentially an umpire or referee who will keep this online and paced.
So before we move off of the role of the commission, which is really our focus here tonight, do you have any questions or thoughts about it? Anything we should maybe talk a little bit about? Want to share a story with some of your new members to let them know how much fun this is? But if there's anything you want to talk about in terms of your role, either as an individual or a group, that'd be great to have words about now.
Yes.
So I'm trusting.
You need the microphone.
That's the easy one.
Sorry. So, Rick Jamerson, trustee. At our meetings, our board meetings, which are similar to this, when someone in the public, especially when there's a heated conversation going on, asks a question, I was told that the board should not answer that question necessarily in public. What's your thoughts on that? If there's a heated discussion going on, or even if someone just comes up and asks a question, should it be answered at that point in time, or is it something that the commissioners here, or even the trustees at a board meeting should answer? Because I've always been told we should just not engage. We should just take the information and let the information come out later. Yes, no?
My first response would be, it depends on the question. If the question is one of determining an existing fact or condition, and you have the answer, it's a good idea to respond with the answer. The reason being is that we want to do everything we can to make sure that the audience understands they're being listened to. If it's simply a question of asking the commission's opinion about something, that's not something they should be responding to at that moment.
Let me give an example of this. During the Lexington matter, many people in the audience raised a lot of questions, and then they said, "You're not answering our questions." Well, one of the reasons is we weren't the ones in a position to answer the questions. That was really the developer. So many times what we said to people is, we're taking down your questions. We're going to ask the applicant to respond to them, but we don't have all the answers either. We're not supposed to. Is that part of what you were thinking of?
And I would emphasize the point that Bruce just made. It's not for you to explain the applicant's case or your understanding of it, or no, if there is a question about what the development is going to do, or how many trees are going to come and go, or where's the detention going to be, it is certainly appropriate to do exactly what Bruce just said. Make the list, let the applicant do it. If the applicant's paying attention, they ought to be taking these exact same notes. So just others to mention, right? The Zoning Board of Appeals has a different role and different responsibilities, and they talk more about variations to existing sections of the code. Relief from the code may come up as part of your deliberations, especially with a planned development, but to the extent somebody is looking for a variation that relates to a unique condition of their property and a hardship that they have, that'll happen at the Zoning Board of Appeals, who also then makes a recommendation to the village board. Speaking of the village board, the reason we put up this slide is to set a little bit of context. So the board, as you know, and again, some of these are just intrinsically understood, but it's worth discussing them briefly. The board has other responsibilities than just the land use issues that you all deal with. They have got a broader policy basis. They're thinking in terms of economic development. They're thinking in terms of budgets. They have other things going on. We anticipate this question because it doesn't happen every place, but in some places, there is often a lot of disagreement between the board and the commission. And the board will recommend A, and the board will take a different position. And what we want you all to know is, well, that's fine, right? Your job is to take testimony, to hear the case, to make a recommendation, but there may be a broader public policy way to look at it. So if the board takes a different direction, that's part of the process, and certainly is not problematic.
On top of that, it's not your job to guess what the board wants you to do.
I think that causes an issue sometimes when, the residents in this case get like fired up thinking, oh, look at the board voted down what the plan commission is doing. They're not going to help us at all. And I think it makes like an adversarial relationship, I think.
I don't think either you or the village board thinks of it as an adversarial relationship. Again, they're looking at it from different perspectives. Your responsibility is to consider what the comprehensive plan directs you and what the standards that are in the zoning ordinance, and you're making what amounts to a technical review and a recommendation based on the facts that you find. The board has more freedom to go beyond the standards in the zoning ordinance or the comprehensive plan. It is a policy making body. If it's necessary, they are empowered to make rules and to deviate from your recommendations. They didn't do that because they didn't think you thoughtfully made a recommendation. They did it because there are other things that they have to put in play. So I'm not speaking for the board, but I don't think that the board looks at any decision that it makes that isn't the same as yours as overruling you.
I just think that it's the residents or whoever's, the audience, if they're the ones that were concerned about how they're going to feel with the hearing, they're going to say, oh, look at the board just shut the plan commission up. And the plan commission understands it. But I think it gets to be a little poison in the audience when something like that happens.
And we've been in communities where that understanding is built into the process. So when you open a public hearing or you start a case, if there are concerned residents that are in the audience, it's not completely out of bounds or unusual for, as part of the start of the meeting, to make clear to everybody, just so everybody knows, right? We as the Plan Commission are a recommending body to the board, and to spell that out, because I think you make a good point. In fact, even some developers will say, well, I'm just going to do what I do at the Plan Commission, and then we'll do the real thing at the board. But the fact is, the public hearing, the forum for the deliberation is here. And in some communities, you don't have to do it every night, but when there's a case or something, is to let people know what that distinction is, because Riverwoods is an informed community. It's an active community. It's probably better informed on these things than other communities would be. But to let everybody know where this meeting fits in the process might be something that you want to be sure that people know at those kinds of meetings.
The other thing is that if more regularly, or it becomes an obvious public difference between the two bodies, so much more the reason that you ought to have joint meetings occasionally to discuss policy so that you're on the same page.
So the role of the planner or the staff, in some places it's a village employee, some places it's a consultant, some places it's a combination of those. It includes a range of people. It's going to include planners and building officials and attorneys and so on. The bottom line is that these folks are all here to assist you. Right? What you need is the collected information that you need to make a good decision. And what all of us in the role of staff are here to make sure that you have that. What I used to tell my Plan Commission in Highland Park was that we see a lot of D work come into the office. And we work with the applicant, and we don't bother you with it until it's at least a solid B+, right? So the staff has been working on this to get it to where it's even worth your time in a lot of cases. And I mention that because a lot of times, if there's a staff presentation, or if you hear one of us talking about a case or an aspect of a matter, we seem to know a lot about it. There are some folks that in the past we have seen get confused. It's like, well, gee, these guys know a lot about it. Who are they working for? And it needs to be clear to everybody that we all work for you is kind of what it comes down to. We're here to make sure that you get the information. Same with the public. When residents call, staff is there to help clarify things, but is not making the case. Just because staff understands what's going on does not mean that they're working with the other person.
Or advocating.
Or advocating in any way. Go to the next slide. Let's go to the next slide. Who else is involved? Obviously, the applicant, the petitioner that's before you, and they have certain responsibilities as well, which is to submit, obviously, complete information. It is for them to make a complete case. If you have questions, they're there to answer them. If there's additional information, there may be a pause for them to get it. But the applicant is really there to provide you answers to the questions. And you've been through this process, those of you that have been on, and you understand it. They don't always give you the answer maybe that you want to hear or in the way you want to hear it, but that's their responsibility. In terms of the public has an important role, and you understand that well, and you've had meetings where concerned residents have been here. Part of the public's responsibility is to be courteous and to be an additive part of the process. Now that's hard when there's emotion involved. And I always tell people, you've got the challenging job of separating the fact from the emotion, right? And it's hard if you live next to what's coming to be able to do that, but you're here to do that for people. And if they seem a little unhappy or upset about what's going on, give them a break, because change is difficult. But ultimately, as we've said, if it gets a little heated, it's up to the chair with the help of others to say, address the comments here. Let's maintain some decorum. Let's take a break or whatever's required to do. But so that's really a responsibility of the public when they come to the meetings.
I think it's important to realize that the developer's responsibility includes putting on their case, which is to say, you're here to measure it against the standards that are in the ordinance or in the comprehensive plan. It's the developer's responsibility to prove their point that they have made all of these standards, that they exceed the standards or at least make the standards. It's not your responsibility to make their case. If they haven't made their case, they haven't proven that they are meeting these standards, that's when your responsibility is to make that recommendation that said they haven't made these standards.
Maybe I'll just throw one thought in here. It has to do with what Michael was saying about taking it from a D to a B or B+. Developers come in with proposals, and we do spend a lot of time looking at what would be the best you could make this proposal? How could you reshape it? In the single family context, we're always saying, well, you could move the house over here, try and avoid the woodlands here. But on the larger track, we do the same thing. Like, what if you did this? What if you did this? And that sometimes is mistaken by the public as taking the developer's side. So when it comes to the developer making its case, sometimes we're the ones saying, you should come under this set of standards because the rest of the standards won't apply. They won't work for you. That'll never work here. But if you're going to come, then you need to meet these standards. So there is this sort of interactive effort at times, especially in Riverwoods, where half of whatever a developer would propose is currently not anywhere allowed in the code. And so in other villages, when this happens, they have more flexible tools already. When someone comes to us, we're almost always saying, okay, take Wolters Kluwer. When it comes to us, what they want to do is not yet probably in the code, or Michael and I were having a discussion, and Lee, about, well, maybe we could just amend the ONR1 district. So one of the things we always end up doing is kind of looking at what we have right now and how we could accommodate something, not because we're already a big proponent of it, but because a property owner has the right to apply for an amendment to zoning. And the developers come in and say, yes, we'd like to apply for an amendment that allows our project. What do we do? And either they can come up with their own solution, which will probably be awful, like it'll be a D, or we'll give them like 2 or 3 possible solutions that we think work better for the village. And so maybe, I don't know, I've said enough. That's just an idea of some of the tensions we have, because the parcels that are left that are going to be developed are kind of unique in terms of how we've processed them.
I agree with that. I think the hardest part of the staff's recommendation is the determination of whether the application is ripe for your review. That is, that we will work to the last minute to get it improved to the point that it at least is a credible proposal, that they've provided all of the data that you are going to need. We predict you will need these data. But the determination of whether or not, okay, this is as far as we can take it. It's time for the commission to review it.
And part of what staff is doing there, and we saw this with the townhome development, is to put forward the question, could you do it this way? Or could you address an issue? Or could you better meet the standards by doing this? And to work with them with that, regarding that. And there's often a point in that process where they say, you know what, can we just go to the commission, please? And they have that right. In which case you will hear from staff either specifically or sort of implicitly, the phrase that I like to call up, should the commission wish to approve this, you may want to consider the following, right? Which my southern relatives would be sort of like, bless his heart. So it's all about setting the table for your consideration. Also being fair to the applicant, making sure that residents and concerned folks have got an opportunity. It's really all about setting the table like that. And the other thing I would suggest to you is that if there is a way to do it better or differently or provide you more than you need, let Steve know, let us know. And that's what we want to do. There is not one right way to do things. There is not, every town is different. We should count how many towns we've worked for at some point, but they all do things differently. There is no right answer. So it's always worth thinking about. The next slide, speaking of other groups, the next slide, so it's quiz time. Which state in the union has got more units of government than any other? Everybody always knows the answer to that question. Yes, Illinois has a process of having very different, very separate.
Pennsylvania is second.
Pennsylvania is second. Yeah, it is. And we need not trouble ourselves with why. And you really need not trouble yourselves with who they are. There are all these other, not just government agencies, but other facilities and neighbor organizations. To the extent that they become part of the process or that there is a question or a concern, staff will deal with that and will let you know what it is. It's very, very rare for members of these kinds of groups to show up at a meeting or to even participate in a process. But when there's something that has to do particularly with school children or maybe something, an impact on a fire protection district, staff will definitely be in touch with them. And to the extent that the information is relevant, we'll make it part of it.
And it's not the responsibility of the commission itself to make that contact.
Okay, let's go to the next slide. So I want to talk a little bit about running the meeting. We got about 20 minutes left and we'll cover that. So the goal of the meeting is really about fairness. You know, I used to joke sometime that we all deal with, what was it, the First, Fifth, and 14th Amendment on a daily basis. So this notion of due process is exactly what you're all doing here. And so the other thing to keep in mind is that not everybody understands the process the same way. Not everybody who's at a meeting understands the process the same way. Not everybody at the meeting has come into the process at the same time, right? So Steve and Bruce and perhaps Lee and I will see something before you do, and then you'll see it, and the neighbors will only see it at the meeting. So always keep in mind that there are different entry points for folks into the process, so that there's going to be those differences. But that said, there are certain tricks of the trade, if you will, here about how to do that. In terms of allowing people to ask questions and giving people time to be heard, there are appropriate ways to not limit testimony or the amount of comment, but to focus it and asking people, could you, if you've got a comment or question, is there something that maybe is new that we haven't heard yet? Or we know that people are concerned about stormwater. Maybe how many of you are concerned about stormwater? Raise your hand, and then note for the record that 25 of the 50 people have raised their hand, something like that. We always suggest that you err on the side of more testimony, letting people say more than less, just because that's what this is all about. The hardest thing to do, and perhaps the most important, is the last one on here, is that the number of people that are in here for or against an application is not one of your criteria for making a decision. right? It's those standards, and we'll get to those in a minute. This is the hardest part of all. This is why we like it on this side of the dais, and so respect those of you on that side of the dais. I was a plan commissioner in my hometown for a little while. It's tough. We get it. But that's the hardest and most important lesson. And if you take one thing away from tonight, maybe that should be it. So let's keep going to the next slide. As I said, there is no one right answer. Communities come up with regulations that are specific to the things that are important for you. If there is an important issue or something that needs to be revised, Bruce will write you an ordinance for it. And the best example here in Riverwoods is obviously the tree protection, the tree and woodland protection ordinance, which, as you know, is delineated on a map and sets limits on what can change. That's just the perfect example of an ordinance that's specific to a community and its character. So let's keep going. So what are special uses? I know I'm supposed to be telling you. So when you look in the zoning book, right, there are permitted uses. Those are the things that people can come and just get a building permit for because they are permitted by right for the use of the land. But there are special uses. And the idea of a special use is not that it is a bad use. It's not that it's something that, well, let's talk about it and decide if we want it. The idea of a special use is that it's generally appropriate for where it's located, but there may be something special about it that creates a unique impact on its neighbors or the community generally that may need to have some conditions placed on it. In fact, some communities, these are called conditional uses just for that reason. What are really good examples? Gas stations are very commonly special uses in zoning ordinances. Why? There's a lot of coming and going. Right? There's a lot of potential conflicts and hazards. There are issues of hours of operation. How close are you to a neighborhood? You just did a gas station, right? So you know these things. Lighting, right? The other good one is anything that's got a drive-through, right? Because sometimes drive-throughs are near residential uses and they have those order boxes with their fries, right? That kind of thing. And so there are issues of whether or not the volume can be controlled, those sorts of things. And it gets to a lot of things. In some places, pet stores and veterinarian offices are special uses because the pets come with potential adverse impacts, right? There's barking. Are they boarding the dogs? Do dogs stay overnight for anything other than medical reasons? So those uses in and of themselves, not bad, but potentially have adverse impacts. So that's why we have special uses. So let's keep going. How do you decide if a special use is in keeping with the standards of your code? Well, you as a group make findings of fact, as you know, and there are standards to ensure that your decisions are fair and consistent, right? And they're in the code, and we'll get to them in a minute. But as you deliberate, you should have these standards in mind, and I've seen you do this, so I know you do this. But this is real important. Those standards become essential for any number of reasons. They keep the decisions fair and consistent, and so they're predictable in terms of the residents or neighbors who are here will say, oh yeah, they did this last time. We're treating everybody the same. We're treating everybody fairly. Those conditions become even more important, or those standards become even more important if there's litigation involved. And these things happen. So it's important to follow these standards. And if you have questions about them, you should call staff, right? I often describe this to commissions as saying, when I was working for municipalities, the thing that I hated to hear most was a commissioner go, you know what I'd like to see here? Because that's not really the question. With all due respect to your expertise, understanding, commitment, and time spent living in Riverwoods, the correct way to think of that is, how does this or can this best meet the standards? Which ought to pretty much be the same thing. But keeping those standards in mind is something that when we do this training for communities, we just emphasize a lot for all those reasons. So let's go to the next slide. We'll see a little bit more about those. So the code has got these standards, right? Now, what's the most interesting thing about these standards? Oh, you didn't think that was a question? They're not yes or no questions, are they? right? So they're not like, is it 45 feet tall or 46 feet tall? What's this, right? These are not yes or no questions. And so this is a way for you all to frame your thinking about the case. This should be the way that the applicant is framing their thinking about the case. I can tell you this is how staff is framing our collective thinking about the case. And like I said, if there's litigation, this is how the attorneys are going to be thinking about the case. So aside from all those reasons, again, this is just about consistency. It's about treating everybody fairly. And the fact that they are not yes or no answers, well, that's the point of it too, is that it's just to frame people's thinking.
If it was yes or no answers, it probably could have been approved by staff as an evaluation against a set of standards.
So that may be the most, I know this is already the third time I've said, okay, this is the most important thing we're going to say tonight. But the findings are definitely on the list. And a great way to frame your thinking too. And the other thing I often say to commissions is, in some ways, especially if there are a lot of residents that are concerned and they're going, how can you approve this? This is going to do X, Y, and Z, or this is going to be too much of water, too much of that. It's important for the residents to understand too that these are how you're making your determination. Yep. We hear what you say, and yes, that's important, but we're focused on these. This is how we look to these. And these, I would tell you, by the way, just as an aside, are well-established standards in Illinois. There was a landmark case in Illinois, 1959, 7, LaSalle Bank. What? LaSalle Bank versus Cook County. And the Illinois Supreme Court set standards for how these things should be considered, and they're found in codes throughout the state just for that. So this is a tried and true method of considering, of deliberating on cases. Let's go to the next slide. So let's talk a little bit too about the development process, right? And so ex parte communication.
Just say one quick thing here before you get
Absolutely.
started. We've had some experience in the village with a lot of ex parte communication. So when we were talking about putting this together, I said, I think we need to go back, take a step back, and really think about a policy. They're happy to do this because professional planners are guided by specific ethical rules on ex parte communications. Illinois is a little loosey-goosey, actually, on it. Some states actively prohibit it once an application is filed or there's a pending matter. Illinois more takes sort of balancing did the type of communication rise to the level that it would have affected the decision in some way. So that's the background for why I really wanted this part in here, and I really wanted us to, we may not resolve everything tonight in terms of a policy, I don't think we will, but I do think that going forward, we'll all be more comfortable if we have better rules of the road, and we'll kind of know how we want to act. That was my initial starting point.
So if you think back 45 minutes when we were talking about the public hearing, right, which is the record for the case that's being heard. That's what is deliberated on. That's what goes up to the village board. That's the case that's being heard. Everything is supposed to be heard there. So what happens if you're at the grocery store and one of your neighbors stops you and say, is that thing going to happen at the meeting? It is such a bad idea. I hope you're not going to let that happen. It's really in your and the village's best interest for you to say, you know what, it is going to be on the meeting this week. And if you have a concern or a question, I encourage you to come to the meeting. And then when they say, I don't have time to come to your meetings, you can say, well, why don't you contact staff and they can help you understand what's going on. And if you have a concern, send an email, write a letter, be involved that way. Don't engage them in a conversation again, because it's contrary to the idea that everything is heard at the meeting. It's contrary to due process. This can also happen if you're visiting the site, right? If somebody is coming for something about their residence or their home or anything, and you're visiting the site because, well, I don't know, I was at a meeting and this guy Mike told me to go visit the site. And the owner comes out and says, you're on the plan commission, aren't you? Let me tell you why I need this. Same thing. And so the reasons to do this are code related in terms of the importance of the public hearing. It's also just a good idea. I've never seen it happen, but I'm really worried about somebody standing up and saying, you know, when I was talking to Commissioner Brown and Woodman's about this the other day, he told me it'd be a great idea. I don't know why he's changing his mind now. You just don't want that to happen. And I haven't seen it happen, but I can see it happening. And so it's best to just say, send a letter, call staff, come to the meeting. What some communities will do is they will actually disclose ex parte communication, right? So you might say at the beginning of the public hearing, Madam Chair, I just want you to know that I had a conversation with a couple of neighbors about this while we were out to dinner. We didn't have a long conversation. I shared with them just the, general take of what's going on, blah, blah, blah. And we talked about it, but I believe I can still make a fair and open determination here, right? Not all towns do that, but as Bruce says, in terms of policies and how to do it, yeah, we always suggest that the rules of the road are pretty clear for everybody.
Perception is really important. Perception of transparency and evenness and equity, and making certain that this is the place where everyone has an even chance of presenting and hearing this. If you were to have that conversation, that ex parte conversation, someone can come to the conclusion that you've already come to a conclusion or that you've been influenced by that outside of the public hearing. We want you to be able to state clearly, it's easy for me to make a decision because I heard it here. And I'm not influenced by some other phone call, email, whatever it is. We would encourage you, if you do get an email or something like that, state it to the chair.
Or if you get an email, you get some information, send it to staff and staff will send it to the entire commission. But again, I just want to reiterate Bruce's point that having some direction spelled out for this is important, especially because in some communities, the rules for elected officials are different because you act in a legislative manner, right, as opposed to a quasi-judicial manner. So the elected officials have got a different role. It's very common for applicants or residents to talk to an elected official or want to do that. The same problems come up, but it's not as contrary to the notion of the public hearing and the same amount of equity because you represent the community in that way. I would tell you when I worked down the road, the rule was that if an elected official was going to meet, staff was with them. And again, for the same sort of thing, for the same sort of protection, right? So that somebody doesn't stand up and say, well, I don't know, I talked to the trustee and he thought it was a great idea. You just want to avoid that. And we don't need to go real deep into it tonight, but again, as Bruce suggests, a policy and an approach so everybody knows what to do and doesn't have to be intimidated by it. And better yet, has got a fallback, right? So when you're talking to somebody in the grocery store and you tell them you can't, like, I'd love to talk to you about it, but the village has a rule that I need to abide by. Just give yourself the out.
I don't remember if we have essentially de facto meetings, but we strongly urge you never to reply all. In most cases, we'll probably send things out as BCC so that you can't reply all, right? Why? Because the moment that you're having a response as a group to the rest of you, or even a majority of you, it is a meeting. And because of the Open Meetings Act, it becomes a problem.
Trustee Hollander?
My guess is you probably can hear me without a microphone.
But you still should, yeah.
During the Federal Life in Lexington process, each of the board members were asked to meet with the folks at Meadow Lake to have them present their side of the story. my guess is at least 3 or 4 of us, myself included, did go ahead and meet with them, walk through the areas involved, and then sit down with them at someone's home and had them ask questions, and we listened to them and probably answered some questions they had as individuals. We didn't go as a group of individual trustees. From what you're presenting here, is this something we should have avoided or should avoid in the future?
Again, as trustees, you're acting in a legislative fashion. It's fine for you to do what you did. What we're suggesting, though, is that so that you know whether or not it's a good idea, that the village have some guidelines about how to do it or whether to do it. Clearly, you know, not 3 of you couldn't go at the same time. You know all that stuff. But how you're going to do it is something that you may want to decide ahead of time, so that when you're faced with the question in the future, you can either say, yeah, absolutely, I'm glad to come, or I'll come, but staff's going to come with me, or I can't, just so that everybody is dealing with it the same way.
Did you disclose? Did you disclose?
No, we didn't.
No,
It was fairly common knowledge, but part of this, Henry, was that I think I was somewhat struck by the total silence on the part of the Lake County Board when the Bridge Industrial matter was filed in Lake County.
Lexington.
I know.
Okay.
What I'm saying is, after we had the filing from Bridge Industrial at the county level, you could not talk to a county board member. And it wasn't because the law said you couldn't, but because they had adopted a policy and they just said, this is what we're going to do. And so it's not required that trustees not have these meetings. They can have these meetings. What Michael is saying is that the Plan Commission should be much more reticent and probably should not have these kind of meetings. And we should probably have some written policy that helps us all make that decision. At the trustee level, it's a different discussion, but there are places that even at the legislative level have policies. And in other states, they have policies where there's even more concern about this. So, I mean, applicants have First Amendment rights, and and people who reside in a village have a right to talk to their trustees. So you're in a different position than the Plan Commission. So it wasn't improper to do that. It's just, the question is, were you all comfortable? Did it help the process that you had these meetings off-site with the developer? Is that, I don't know that other villages would have all done that. Some might have. I don't know. Maybe I'll throw it back to you guys.
We advocate for clarity and consistency. If the village consistently wants to support that, I would say that you should consistently report it at the time that the village board is making a decision, rather than some people in the audience knowing that meeting took place and others didn't.
So again, probably something for further discussion. Yeah, and you can go to the next slide. Ethics. Again, what's the old rule? If you don't want to read about it on the front page of the Tribune next to certain Chicago aldermen, don't do it. Is probably not a bad rule. But again, there are ethics laws in the state. There are ethics laws that a lot of municipalities have and are very specific about. And again, that's very local. If you have a question about whether or not something is an ethical issue, check with staff, right? And staff will talk with the village attorney and will help sort it out. These sorts of things are very rare, and Lee teaches ethics to planners all over the country. And my takeaway from the kind of training that Lee does is it's not the big stuff that's complicated. It's not somebody offering you $100 to vote for their case. It's I don't know, can I go to dinner with them? We're both in the Rotary together. Is it those things that are kind of gray and small, I think, are the harder ethical questions to deal with. And if you've got a question, call staff. Let's keep going.
I always find that the appearance of impropriety is the tricky part.
You have anticipated the next slide, Madam Chair. Well played. Conflict of interest is the real good one with that, right? And it applies to ethics, but also conflict of interest. There's always a question about, is this a conflict of interest? And so the real answer to conflict of interest is if you have a personal financial gain, right? So if if you're a member of the country club and they come for zoning, is that a conflict of interest? Unless you own it, hey, God bless. You know, it's not a conflict of interest. If you own a piece of property, if somebody's looking to develop a store and you're going to sell them the fixtures that go in the store, yeah, those are financial gains. That's a reason to recuse yourself. If your neighbor comes before the group, if your brother-in-law comes before the group, those are not conflicts of interest. We had somebody say once, I own stock in Amazon and they came before the village. Was that a conflict of interest? A really good question. If you own a percentage of
2%, I believe, is the law.
Right. If you own 2% of it, you know, God bless. What are you doing here?
What are you doing here?
Right. So there are very specific rules about what makes conflict of interest. If you have a question, I'll staff. But more to the point, as you said, Madam Chair, the perception of conflict of interest is frankly probably as important as a real conflict of interest. And there's a couple of ways to do that. If you have a real conflict, if you really are conflicted, if it really is your brother-in-law and you're really not sure that you could be fair because, you know, you really like him, well, that may well be a conflict of interest. But the trick to dealing with it from an appearance standpoint is to disclose the potential conflict, is to say, I'm a member of the country club, I don't own it, I'm not a member of its board, so on and so forth. We had a case when I was in Highland Park where one of the congregations was coming before the city for an application. I think 5 of the 7 members of the Plan Commission were members, right? So if they'd all disclosed themselves, we wouldn't have had a quorum to deal with it, right? But everybody disclosed. They said, I'm a member of the congregation and I'm, you know, not on the board, not anything. And I know that I can make an open and fair determination here. So that that disclosure of the potential perceived conflict is an important part of that. And again, if you have questions, check with staff. Just 1 or 2 more slides and then we'll wrap up. But the Open Meetings Act, and Lee alluded to why this one's important. There's state required Open Meetings Act training that you've either taken or will take, yes? And that's sort of the by the numbers version of it. But again, you kind of get to the perception and some of the strange stuff too, which is, as Lee said, don't ever apply all, just don't even think about it. You know, and the meeting, what I like to call the meeting after the meeting, where 4 of you are standing in the parking lot afterwards before you go home. Don't talk about the case. Can you talk about it after it's been decided is the question we always get. And what we tell people is if it's been decided by the village board and it's final, yes. If not, no. Why? One of the options the village board has is to refer the case back to the Plan Commission for further deliberation, right? And so if all of you or 3 of you or 6 of you are at a dinner party together, is that okay? Do 3 of you have to leave? No, you absolutely don't. Don't sit there and discuss village business. But these are the things that you sort of find yourself happening. And it's one of the, it falls in the category that I like to call, it's not a problem till it's a problem, right? And so when there's an issue or there's litigation, things get upended on the strangest things. In fact, here's another good one, is when you're sitting here, don't check your texts or don't send a text that says, I'll be home by 8. Or this guy won't shut up, I won't be home till 9, right? Because, well, one is there's the appearance of what's going on. When people first started having laptops in front of them, I had one Plan Commissioner come up to me and say, I was emailing with one of the aldermen during the case to hear what he thought. And I just thought, no, oh God, don't do that. Part of it is perception. And the other thing too is it was a case out of Champaign several years ago already where there was litigation And they disclose, they had to, during discovery, the texts of the city council were disclosed. And so some attorney was sitting there reading the texts from the city council in Champaign to see if they had colluded or done whatever. So it's the most innocuous things that become problematic. One, because of perception, because of the folks watching, and two, ultimately because of case law.
Yeah, let me just say about that case, because it is really important. The Open Meetings Act, no one ever thought that these are private phones, these weren't village-issued phones. The Illinois Supreme Court, or was it the PAC, now I don't remember, said, if you're communicating during a public meeting with your private phone, the communications on your phone are public messages. And therefore, you lose all privacy in your phone to the extent that you're using it during a public meeting. So don't do it.
Once again, technology is our friend. We've got one more that we wanted to cover before tonight. We'll go to the next slide. This is a model of a public hearing process. And no, I am not going to read you all 14 of these steps. But this is not, again, I'll repeat again, this is not the right answer, right? There are a lot of ways to do this. What's important to know is two things. One is there is a structure to a public meeting and a public hearing, right? In terms of the agenda, an agenda is one of the pieces of the structure. The reason that structure is important is so that all of you as commissioners know what's happening. The applicant knows what's happening. Any residents that might be here know what's happening. It's particularly important because as a resident who is not familiar with this whole process, you come to the meeting and you're just sitting here and you're listening to the applicant, and then the plan commissioners are talking and the staff won't be quiet. And there's just all that. And as a resident, you're sitting going, what about us? Right? And it's got this feeling of not being fair, quite honestly. So to know that there is a structure and to share to whatever extent is appropriate that structure with the folks that are waiting or that are part of the meeting is important to do as well. And we've seen any number of ways to do this. The one that I kind of liked, I think it was just in Lake Forest.
Yes.
They had kind of this down the side of the agenda. So where you've got the agendas that people can pick up at the podium, it's not this detailed. Actually, it's Lake Forest, so it might be.
And the rules related to the length of how long you have available to speak to it, and the notion of redundancy is not invited.
Sometimes the chair, when they open the public meeting, will read a statement to similar effect. We'll read the order of the process, if you will. Again, these are just good government kind of things. They're a way to make sure that your process is fair and consistent, and that most importantly of all, the residents and the neighbors know what's coming. So I'll repeat it one more time. There's no right answer, but having that structure and having it clearly understood is important. The slides that follow, and you've got them in front of you, the slides that follow are more about code than procedure. We kind of hope that in an hour tonight we could, not bad, we could get through the procedural aspects of it. So that's as far as we wanted to go for tonight. If you have any questions or comments or anything for discussion, we're certainly glad to do that. But if there's nothing else, then Madam Chair, I give you back your meeting. Oh, you have a question, I think.
Can I have a little input on the structure and ramifications of appearance review commissions? Because we've been talking about that with a potential development, and I don't know how far it goes, what it includes, what the responsibilities are. Give me an idea.
I worked for the city of Highland Park. I think you were still in grade school at the time, for the Appearance Review Commission. And in the beginning, and they were not the first village to do this, it actually, Glenview had it before Highland Park did. There was a relatively vague set of ideas about what makes something attractive. The commission seem to have free rein on their own perspective of what made things attractive, and they would opine. And frankly, it caused all the other communities to say, that's not a good idea. We need to put standards that are measurable in place so that both we as a commission and the applicant and the public have a degree of confidence that they're going to see a consistent set. So it isn't, I really don't like the color of yellow you're using in that sign. It's, here are a set of colors that are acceptable within this area. Here are the types of materials that we find to be consistent with the kind of style of building that you're building. We don't want to hear, we kind of like Tudor. That would be good. Can you bring Tudor in? Historically, most of the appearance review originally came from monotony ordinances, where a municipality wanted to avoid all the houses looking the same. Then it got shifted around and other things were brought into it. So the answer is it depends on what you're trying to accomplish, but whatever you do, you should be able to reproduce it, whether you're sitting in the chair or 5 years from now, your daughter is sitting in the chair. There ought to be a consistent means of measuring, is it or isn't it consistent with our standards?
Just to be clear, you were talking about for commercial developments. You're talking about review, appearance review potentially for review of commercial developments, not single-family homes.
No, it wasn't single-family homes, but it's multi.
Anything else out of
Anything that is not a single-family home.
Yeah.
But I remember I had a friend who was building a house in one of our adjacent communities that has an appearance review. And in the original design, there was supposed to be an oval window at the top of the staircase looking out. And they decided that it would be more cost efficient to put in a rectangular window. And that village, their appearance review, stopped the building of the house because the window was the wrong shape. And yeah.
But that's not what we're talking about here for River Woods.
No, but that's what I'm saying. That's why I think there has to be, and that's why I asked, limitations as well as assistance for all of us with something that's entirely new that we may be dealing with.
Well, one of the things that, and it's actually one of the later slides here, it's, how to deal with a large-scale development, anything that's not single-family, where among the standards for excellence, to some extent, are the quality of the materials and its appearance.
I saw that.
And, we asked Bob Hammer probably a little late in the day, who's the architect, his firm designed the Village Hall, to provide a review and suggestions of the Lexington project, for example. He did, and they made some last minute revisions that really, they weren't able to really make a good case for. They couldn't present. So it may be that in some future, next time we look at how to process a plan development or a conditional use or something for Wolters Kluwer, for example, or one of these other, or even Federal Life, if it comes back, that without having an entirely separate appearance review commission, which may only meet twice in the life of the village.
Actually, I think we talked about appearance review with regard to this board, which is why I'm concerned about it.
Well, I'm saying maybe that there would be some, again, standards written into, and Lee's shaking his head, he knows where I'm going with this, that it gives us something to look at that characteristic as part of the plan commission review.
The most successful appearance review commission is working with commercial districts. The district is already of a style or character or a scale, a density, a height that has already set a standard to which you can compare the new development to, whether it's infill or redevelopment. The more difficult ones are open sites or 5 acres, 10 acres, 15 acres, where they're going to establish a standard that's independent largely of their surroundings because they're large enough to be able to do that. What is most common these days on that kind of site is requiring the developer to prepare what's known as a pattern book. which is to say, we're not going to determine in advance the nature of the design, but the developer is going to propose it, and they're going to propose it in a way that they will be measured against that once it's approved.
Any other questions or comments? Thank you very much. That was very helpful. Shall we move on? Our next order of business is old business, the continued discussion of the sub-area plan involving Walters Kluwer. Do we have something tonight to add to that?
Well, I don't. We have heard that a destination-type spa, I don't know how to quite characterize it, destination-type spa facility, has expressed interest in buying the Walters Kluwer site and keeping the building, adapting the building. That may not happen because they may not reach terms for a contract. But if something like that did happen, then what we understand so far is that they're interested in keeping the building. So in terms of the sub-area plan, we kicked around a few ideas of what does that mean. It's in an office and research campus district right now. It may be that a use like that could simply be snuggled into that district. Go ahead, Lee.
So one of the things that Michael referred to earlier was a distinction between special uses and conditional uses. And some communities use the term interchangeably, but more communities really make a distinction. A special use is that characteristic where occasionally, under certain circumstances, these are permitted and fit within a certain site. The conditional use is more on the order of, if you meet these conditions, it's a permitted use. And so there's a whole list of conditions that are predetermined, and you're essentially measuring it against those standards. So we're at a point, at some point, we should be considering what's the best tool in this situation. We're not there yet.
Yeah, but this, Trustee Hollander, this conversation came up in part because of your desire to have a process with more standards known in advance that made the process less uncertain, subjective, where we sort of decided more clearly in advance what we would be willing to consider if certain things were met. And so Lee had said, well, maybe a conditional use would be the right way to approach something like that. So we have nothing else right now because we're kind of in a waiting game.
Great. Well, that sounds very interesting. Moving on, comments by the chairman. The only thing I'd like to do is welcome our two new members, Catherine Romanelli and Mike Marshall. Thank you for agreeing to come on the commission. We look forward to working with you. And now NJ Dot has moved on to the Zoning Board of Appeals. So he'll be with Sherry on that, on the ZBA. Anyway, we look forward to working with both of you. Thank you. I have nothing else. Does anybody else have any thoughts or comments? If not, I'll entertain a motion to adjourn.
So moved.
All in favor?
Aye.
Any opposed? Thank you very much. Good night.
He gave me a contract.
Yeah, but after that, you will join me on your phone.
Oh, that was, I just live.